What are some financial pitfalls if you are contemplating or going through a divorce? Find out next on Practical Law. Stay tuned. Welcome to Practical Law. I'm your host, family law and divorce attorney Henry Garnbine. I'm also pleased to say that Practical Law is now being co-sponsored by the Oakland County Bar Association. When someone is going through a divorce, it's not only a difficult legal time, financially it can be very traumatic, and emotionally it can be devastating. Today on Practical Law, I'm pleased to welcome as my guest Ken Gross as we discuss issues with regard to divorce and the financial impact. Ken, welcome to Practical Law.
Henry, it's good to be with you.
First of all, why don't you tell our viewers a little bit about your background and who you are?
Well, I'm an attorney. I've been in the Metro Detroit area for 35 years, been practicing law for 32, and for the most part a business attorney, but starting back in 2008, our firm is also specialized in financial crisis issues as a result of the problems with the economy. So all through that time we've helped people with tax problems, financial issues, and you and I ran across each other because we had a discussion, because in divorce there's some key financial issues that come to play.
Why would there be key financials coming to play in divorce more than perhaps in some other areas?
Well, you know, at the time of the divorce, the settlement or the resolution in that case is going to divide up assets and it's going to divide up liabilities, along with all the support issues for the children. A lot of people focus on the assets, but the problem that lingers is the liabilities. For instance, suppose you have joint credit card debt and you have $50,000 of credit card debt. The husband agrees to be responsible for the credit cards. And then after the divorce is finalized, he doesn't pay those cards. As he doesn't pay those cards, it affects the wife's credit rating, and ultimately, if the credit card company sues, she can be sued. People have the misconception that when they go through the divorce and the divorce judgment says husband has to pay for the liabilities or wife has to, that the other parties dissolved of the responsibility, but it doesn't work that way.
You know, you're raising a very important point, Ken, because that often comes up in discussions where I'll explain to my clients a divorce is between a husband and a wife. Third parties such as credit cards, mortgage holders, lien holders, they're not bound by it, they're not a party to it, and they can go after you despite whatever the language is in a divorce.
I know, people have a hard time getting their hands around it. I always call it the creditor rule. And if I'm the creditor and I'm owed the money, what you do with other people doesn't have anything to do with me. Unless I say you're off the hook, you're on the hook. So on the credit cards, you're on the hook unless the bank says you're off the hook. On the mortgage, you're on the hook unless the bank says you're off. And nobody asks the bank, am I off the hook? And if you ask the bank, they're going to say no, you're still on the hook.
Let's start with credit cards. I mean, what would you advise a client where, going back to your example, there's $50,000 in credit cards, they're joint. Husband says he's going to assume them. What do you do?
I would argue you have to look and see where the husband's finances are. If there's a chance that you can see him going forward and not paying those credit card bills because of his own financial problems, you can pretty well assume that after the divorce he's not going to pay them and it's going to fall back on you. On your side, you have to look and say, could I file a bankruptcy and get out from under those responsibilities, or might I become liable and have to have my wages garnished and deal with the problem on my end? You need to take into account those factors when you're meeting with your divorce attorney and hammering out the settlement. Sometimes it's better to make sure that the only credit cards that you're left with are the ones that you're responsible for, not the ones that the other spouse is responsible for if you've agreed to indemnify them or be responsible. So it's a complicated issue, but you got to walk carefully on it.
Let me throw some ideas at you that I've done and let me ask if they work. Same $50,000. Let's say there's enough in a 401k. I've had cases where we've rolled over the 401k to the wife because she's in a lower bracket. Had her then pay off all the credit cards, but you roll off enough additional funds from the husband's share or off the top to pay off credit cards and do it that way. Is that something that would work?
Absolutely. It works well for the wife when you're representing her because she gets you're paying a lower tax bracket on taking the money out of the 401k and paying the tax. She gets the money, she can pay off the credit card, she doesn't have to worry about it. The only time I would turn that around is if you're representing the client that says, that comes in and we look at her finances and say, hey, go ahead and assume the responsibility for these credit cards. Don't worry about it because we can discharge them in bankruptcy. Then in that case with the wife, I would say keep the money in the 401k because they can't get to that in the bankruptcy, and then I discharge the credit card debt. But then you have to be careful that make sure she hasn't agreed to indemnify the husband on the credit card debt.
Okay, so there's a lot of language and same scenario. What if you had a clause where it says in the event that the husband goes bankrupt, there will be an alimony award in the amount of what the credit cards were and spell it out? Would that work?
It'll work this way. In bankruptcy, your obligations under the divorce judgment, whether it's property settlement or alimony, are not dischargeable under Chapter 7. In a Chapter 13, which is we call it a wage earners plan, where you pay back part of your debt, you can discharge the property settlement, but you can't discharge the support or the alimony obligation. The problem with what you're saying is the law, when they analyze it, is what was the real obligation. If it was really a property settlement and you're now relabeling it alimony, that gives the other side the argument to say it still should be dischargeable in the Chapter 13. But it's a fine line in terms of arguments. The big question is you're protected completely by your ex-spouse filing the bankruptcy unless that ex-spouse is filing a Chapter 13.
Same scenario. What if you do it where you set up enough spousal support to cover the obligation, so it's actual spousal support, and it says it's for the support of the spouse, and part of the obligation of that spouse is to pay off the credit card?
Well, it works fine from the standpoint that you still have the spouse on the hook, but and I don't want to pick on the guys,
right.
But if I say he doesn't make the payment and doesn't pay the credit cards or make the support payment, you're still going to have the problem with the credit card company. But it's not. It's sometimes you're choosing between the lesser of two evils, so that's not necessarily a bad way to go.
You know, I'm always trying to think of, in my practice, it depends whether I'm representing the husband or the wife and who has the debts, who has the primary income, I'm looking for ways to protect someone in the event of bankruptcy, or I've had cases where we do file bankruptcy either before or during the divorce as part of the plan. So, it's a real tricky area what you're dealing with when you're dealing with third parties and creditors' rights.
Yeah, and you also have this complication. If sometimes a husband and wife decide their marriage isn't working and they want to get a divorce, and although there's always tension in the course of what you go through, sometimes there's a level of rationality on both sides, between both attorneys and both sides, and then there can be an opportunity where bankruptcy before the divorce is resolved is a planned method of getting rid of the debts so that the couple can move forward without that problem. So sometimes there's an opportunity to plan working with the other side, whereas in other cases, which I'm sure you've seen probably too many over the years, where there's no communication, then the planning goes on a single basis, and you have to look and say, where am I going to be 2 years after that divorce? We've been talking about credit cards. What about the house? The house is the bigger one. That's years back when houses had equity, and a lot of times the wife would keep the house and she'd be responsible to make the payments, and try and get the husband off the hook on the mortgage. Well, that was always a difficult task because the lender's not going to let you off the hook. But at the same token, there was equity in the houses. In the last 4 or 5 years, we see where the equity evaporated. The spouse decides she can't or he can't make the payments on the house. They let it go into foreclosure. Then the other spouse says, hey, you're obligated under the property settlement to indemnify me for the loss as a result of the house. You've harmed my credit and everything else. Those are big problems. Those are the things I'm sure you're dealing with all the time in terms of trying to protect against it.
Well, you know, now what's interesting in this area, basically, used to be that a house was the major asset of a marriage. Now it's no longer the case.
Sometimes it's the major liability.
Exactly. And I have a lot of cases where one will agree to take the house, and what's interesting is, let's say the house is underwater by $40,000. The courts generally will say, you take the house, you don't get a $40,000 credit against something else. You just take it because we're not putting a value on it, and who knows what will happen. You may keep it for 5 or 6 years and there will be a positive equity, so it's a win or lose situation, and these are things that
I think it's a bad deal because even the spouse that takes the house and gets no credit because it's underwater, the other spouse has the bigger problem because the spouse who takes the house underwater finally realizes, why am I paying for this house if there's no equity in it and I can't afford it? They stop paying, then the bank forecloses. They then have a right to sue both spouses for the deficiency. If I was the spouse sitting on the house and the other spouse wanted the house and it was underwater, I would be saying to him, no, let's short sell this house before the divorce is over. Let's put in the order it has to be short sold and gone so that we have every opportunity to getting off the hook from the bank on any claim of a deficiency.
You know what's interesting? I think your point makes a lot of sense, but I have a lot of people who still want to keep the house despite the fact that it's underwater, and will have indemnifications and everything else, but you know, there are clearly risks.
Yeah, because you go and you make that indemnification, then you can't file bankruptcy. You could file bankruptcy to get off the hook from the bank, but let's say, assuming you lose the house, but you can't get off the hook from your ex-spouse if you've indemnified them because it's part of the property settlement.
Are lenders as willing to do short sales today as they were 3 or 4 years ago? 3 or 4 years ago, it was very, very common. Now real estate's coming back. So my question is there more of a reluctance to do a short sale now than, you know, when things were much worse?
I think lenders have gotten a little bit more difficult in approving them. A lender will always make its own evaluation of the market value of the home and come back to you and say, we will accept this amount in full satisfaction. So let's say the mortgage is $275. The lender comes back and says, we'll agree to take $240. But if the sale price is only going to net the lender $235, then you have that $5,000 of shortfall where either you have to pay the lender the extra $5 or you negotiate it out by getting the buyer to pay a little bit more, getting the brokers to take a haircut on their commission. You do everything you can to make the deal work. Lenders are still willing to do it, but they're getting, you know, and it depends on the lender, and they're getting a little bit smarter because property values are a little bit higher. But it's now a recognized thing. You know, my joke is this: in 2006, if you asked somebody what a short sale was, they would have said it was either a term in the stock market or somebody who was short selling something. Right. Nowadays, a short sale is a recognized way of selling a home. So I would say the answer is, yeah, you can still do it. It's not as easy as it was in 2011, but it's still definitely a viable alternative.
Let's go with another scenario on houses, because the market's turning around, and I have a lot of cases where clients will put a house on the market and there'll be bidding wars. And a lot of houses are going for way over listing. My question, Ken, is you have a situation where, let's say the house appraises out at $300,000 and someone is willing to pay $350,000, but for a mortgage it's only going to appraise at, let's say, $280,000 or $290,000. What do you do in that situation?
That's a hard one. I mean, and you see, it's a good problem from the standpoint that when you're in the seller and all of a sudden you have the buyers with the bidding war. And we saw that last year, and we're probably going to start seeing it, right now as
It's
now that
happening.
the weather's getting warmer.
Because there's a lack of inventory still.
You then take the buyer that's putting in the bigger down payment. The buyer who comes in there and says, I'm willing to pay, an extra $50,000 or $40,000 for the home. If that buyer's coming in with 40% down, he's got a cushion and doesn't have to have the appraisal as high. The guy who's coming in with 5% down, he's not going to get that one. He's not going to get that mortgage approved. So the smart broker would be counseling the client, saying, "Hey, let's take the better deal. You want a pre-approved buyer. You want a bigger down payment if you think the house is going to sell for more than appraised value." And you then argue with the banks a little bit on the appraisal, but arguing with the bank about the appraisal nowadays is not like it was in the old days. They pretty well don't listen to you when it comes to appraisals.
Let's talk about health some more. Let's take a scenario where the house has some equity. Let's say there's $25,000 in equity.
Okay.
And the question is, do you keep it or sell it? And a lot of clients, I'll often tell them to get out from under a house. But it's an emotional thing, and especially, I think it's more women than men become very emotionally attached to a house.
And probably even more so in the midst of a divorce where there's a
Yes.
lot of emotion and it's an emotionally charged event.
But I'll often tell people, unless you're getting a great deal, often a house is a money pit. And are you sure you want that house? Because one thing that a lot of people don't understand is in family law and divorces, if you're keeping a house, you don't deduct for real estate commissions and closing costs. It's a value, whatever the market value is, less the mortgage. And I will tell people, unless you're willing to keep it for 4 or 5 years, unless there's a lot of equity, you're going to lose because of the fact that if you sell it, you're going to have 6% real estate commissions approximately, another 1% for
Sure.
transfer, and possibly some cost for repairs. So
People should listen to their attorney.
But they don't.
But they don't. But think of your own house. Forget about divorce. Forget about anything. Every house is a money pit.
right.
If you've owned a house, anyone out there who's owned a house for 25 years knows it's a never-ending money pit. So if you're in that situation and there's marginal equity on it, it's houses are not what it's not what they used to be. It used to be buy a house in the mid-70s or in the mid-80s, it's going to go up 5-6% in value every year. It was a great investment. Well, we learned that was not true. The bubble that burst in 2008, we've seen a rebound, but it's great. We've seen a rebound after we sustained a 40% decline in property values. Yeah, maybe we've made 20% of it up, but we're still 20% below the line at this point. So I think it's good advice to stay away from the house. I think the one who has to really hold the line is the spouse that's not keeping the house, who's still exposed on the mortgage, is the one who has to take the position, no, I want that house sold. Because that's the person who has potential liability and no real gain.
Unless there can be a refinancing, and then you've got to look at the economics of each party as to whether or not the other spouse who's keeping the house has the ability to do a refi.
Yeah. If the spouse who's keeping the house has the income and has the credit, then I would go and get it refied before I finalize the divorce, if you really wanted to play it safe.
How hard is it to do a refinance now or to do an ovation? And for our viewers, an ovation is where you have a name removed without doing an actual refinance. And I've heard that's difficult.
It's very difficult. It's really the same as a refinance. They have to completely underwrite and approve the spouse who's going to keep the home on that spouse's finances, balance sheet, credit. And if they conclude that they would make a fresh loan to that person, then they'll give an ovation or a release. The whole refinance situation now is lenders want to loan money because actually refinancing is down right now because interest rates slipped about a percentage from last year. But the paperwork and the underwriting process is much more onerous than it used to be. So you have to go through the process. A lot of people are tearing their hair out. There was just a recent article, I think, in the Wall Street Journal a couple weeks back that cash sales in the first quarter of 2014 took up 33% of the market on all existing home sales.
That's huge.
It's huge, and a lot of it was elderly people who were selling their existing home and downsizing, and they said, listen, we'd rather just pay cash for the house than go through the hassle and aggravation of applying for a mortgage.
I heard mortgages are down as far as.
Yeah, they're down because interest rates are down a point. The refi is what's really down.
Well, if interest rates were down a point, wouldn't that increase?
No, I said it the wrong year. Thank you. I said it wrong. Interest rates are up a point from
Okay.
last year, and that's
Okay,
caused
yeah.
that's caused the refinance market to kind of evaporate. And in fact, the lenders are talking about laying people off in those departments.
So, despite the fact that the economy's getting better, there are still areas that are tough.
Well, if you think on the global part of the economy, student debt is a big problem. And the student debt is like 1.2 trillion and growing at a remarkable rate. If our kids coming out of college have $150,000 of student loan debt with a payment that comes out to be $850, $900 a month, how are they going to be able to afford to buy a house? We didn't have that burden. I graduated law school in 1982, and I had $3,000 in student loans, and I had a $49 a month student loan payment. It's a lot different world then.
Well, it's a different world now. And in fact, I was talking to someone this morning about it. The fact is that, and that's a big issue in a lot of divorces. I mean, what do you do with student loans? I mean, if it's a long-term marriage, shouldn't they be paid out of the marital estate? Or, I mean, what advice would you give with regard to student loans?
Well, if I was representing the spouse who's on the hook for the student
You
loan,
want the
I'd
other
say
side
it's
to
certainly a
pay, or-
marital asset or a marital obligation. It's a
Exactly.
difficult one because it's non-dischargeable in bankruptcy as well. So, if it doesn't make a lot of sense for the spouse who's not on the student loan to indemnify on it, because now that person has agreed to be responsible for a debt that will also, and that obligation is non-dischargeable in bankruptcy as well. But you have to deal with it. It's like you said, so often you're probably dealing more with the liabilities than you are dealing with the assets.
Right. That was especially true a year or two ago.
I'd say
now it's
I'd
changing.
say you take the student loan and the dog. How's that?
Yeah, exactly. Dogs are property for our viewers, and judges do not like to deal with them. You can, and as a rule in Michigan, you cannot have visitation rights with pets. They're property, and in some states it's different, but in Michigan, they're property. What about medical bills, Ken?
Medical bills is the same issue as a credit card debt. It's a liability. There is actually law in Michigan that can make a spouse liable for the medical bill of their other spouse. I've encountered that over the years, where the wife who is non-working incurs medical bills in her name, and then the hospital ultimately sues both wife and husband. There's old case law in Michigan making the husband liable on it. But basically, it's the same as a credit card debt. You got to look at it the same way. You probably should view it as a joint debt, as opposed to being just the debt of the one person because of the case law that's out there. Another difficult issue.
Yeah, well, debts are always difficult. What about?
One other thing on the debts, hospital bills and credit card debts. It's not always about bankruptcy. There's another way of resolving those debts, and we call it debt resolution. And depending on the creditor, like for the most part, if your situation, you've gone through a divorce, you have low income, you can usually negotiate pretty good settlements with credit card companies and hospital claims on relative to medical bills, and avoid bankruptcy as a way of doing it. And sometimes you need to bring that into the fold in the context of how you're addressing the property settlement.
So that's something that should be looked at during a divorce, because if, let's say there are $50,000 in credit card debts or debts and medical bills, what's a good resolution? I mean, in negotiation, could you get 25 cents on a dollar?
It's funny how it works. It depends on who the credit card companies are.
Okay.
And if a client comes into me, and I don't want to say it on the air, because if the credit card
Right.
companies are listening and they know that they have the reputation as being easy versus hard, it could impact on things. But I'll go and I'll look at who the credit card companies are, and I can basically tell you, this is what we can settle this card for in the range, whereas this card, it's going to be a higher range. And then I'll make an estimate of, this is how much it would cost to settle. We'd have to wait about this period of time before we could accomplish it. But then it would give you a guide and a way of planning out what the outcome is. It's not so much what the settlement is, it's what the outcome is at the end of the day.
Let's say take it a step further with the debts. Let's say there's a lawsuit against one or both spouses. Is it harder to negotiate when you have attorneys involved, or is it easier once they're reduced to a judgment and there's not a lot of collectability?
It's best to negotiate before it's reduced to a judgment. When the attorney's involved and he's filed suit, as an attorney, we prefer to negotiate with attorneys because attorneys at least understand the same language. You can negotiate at that point. It's funny in the credit card business. Right now, your best settlements are usually made at the collection level just before it goes to a lawyer to sue the person. But those settlements are usually for cash or very short-term payouts, 3 or 4 months. When the case gets to the lawyer and the lawyer's suing on the credit card debt, sometimes you can get a longer period to settle the case. You can sometimes get up to a year. But cash is king in every settlement. The more money you're willing to put out there in cash, the greater the discount you receive.
What are some other strategies that people in the area of divorce should be cognizant of with regard to, debts?
Well, I think the important thing that you really need to look at is evaluate the situation from the standpoint of the house and the credit card debt are the two dominant issues. The other thing that comes up, and you and I have been talking about this in a recent case that we were collaborating on, is what if you have a business that's at issue and you have the business is owned by one of the two spouses, but the business is going to be what provides the income and the support where the support payments and the property settlement's going to be made. The spouse that's not going to be in control of the business, that's going to be dependent on receiving that money, needs to try and gain protections in the course of the divorce judgment in case the business starts to falter. What if the business isn't paying its taxes on time and there's payroll taxes that are due and there's liens coming on? You need to have a way of inspecting, you need to have a way of gaining access to the information to see if there's a problem, so a right to inspect the records of the company on a periodic basis. And then if there's a default, if there's a failure to pay the principal debt on major credit line, or if there's a tax lien filed against the company, you need remedies to go in there and try and step into the business before it goes under.
Ken, we've run out of time. This is very, very important. I think it's important to talk to an attorney before you do anything, whether it's a divorce, credit issues, but the old saying, knowledge is power, and this has been very, very helpful. So I want to thank you for being my guest on Practical Law, and I want to thank you for watching Practical Law.